bankruptcy notice is a formal demand for payment issued by a creditor to a debtor under Section 41 of the Bankruptcy Act. It's issued after a creditor obtains a final judgment or final order against the debtor. A bankruptcy notice can only be issued against a natural person, never a company, and it must relate to a final enforceable judgment debt of at least $10,000. Once served, the debtor has 21 days to comply. Compliance means paying the debt in full or entering into some sort of payment arrangement that is satisfactory to the creditor. Failure to comply with the bankruptcy notice within 21 days is an act of bankruptcy. An act of bankruptcy allows the creditor to file a creditor's petition in the Federal Circuit and Family Court of Australia, seeking a sequestration order to make the debtor bankrupt. There are strict requirements. The judgment must be less than 6 years old unless extended by the court. The notice must be drafted correctly, must not overstate the amount owing, and must comply with the forms approved by AFSA. Service must be valid, and any defects can allow for a debtor to apply to set aside the bankruptcy notice. A debtor can apply to set aside a bankruptcy notice if the judgment is being appealed, if they have a genuine offsetting claim equal to or greater than the judgment amount, or if there is a defect in the notice that causes substantial injustice. The debtor must act promptly and file the application before the 21-day period expires. If the debtor does not comply, does not negotiate payment, and does not successfully set aside the notice, the creditor may proceed to file bankruptcy proceedings based on the act of bankruptcy. A sequestration order places control of the debtor's property and financial affairs in the hands of a bankruptcy trustee. Contact us today for a free 30-minute consultation with our experienced debt recovery professionals and let us help you protect your rights.